Okay, so you guys have really gotten us thinking with all this stuff about wills, and how they actually work when it comes to getting your stuff to the right people. I mean, it can get pretty complicated.
Yeah, for sure.
And we're going to sort of cut through all that complexity and try and make it crystal clear for everyone today.
Yeah.
We're going to look at the different types of gifts that you can find in a will, and even more interesting, like how a gift can go totally wrong.
Right.
Even if the will itself is totally fine.
Yeah.
So this is kind of like a crash course to make sure you don't end up with a headache
Totally.
later on down the road, right?
Yeah. And I think what we've got here brace it down really nicely between the types of gifts you might see in a will and then all the things that could go wrong.
Right.
And I think what's really interesting about this is how the law tries to balance what someone wanted to happen with what's possible, what's fair.
Absolutely.
Based on the actual legal principles that apply.
Yeah, so let's get into it then. I mean, the first thing we see in the material is these different flavors of gifts that you might find in a will.
Yeah.
We see specific gifts, general gifts, and demonstrative gifts.
Yeah.
So let's start with specific gifts.
Okay.
Like, what actually are they?
So a specific gift is exactly what it sounds like.
Okay.
It's a gift of an item, a particular item that's specifically mentioned in the will. The source material here defines it as a particular item or piece of property that's distinctly mentioned in the will.
Okay.
So, for example, you could say, my first edition copy of To Kill a Mockingbird.
Right.
To John Smith, that's a specific gift. It's one very clearly defined thing.
I see. So it's like that exact thing.
Exactly.
Got it.
Very clear.
And that makes sense. And then things start to get a little bit dramatic here, because the material mentions this phrase, ademption by extinction.
Oh, yeah.
I mean, that sounds like a mystery novel or something. So what does that mean in the world of wills and this kind of stuff?
So ademption by extinction happens when that specific thing that was supposed to be given as a gift isn't around anymore when the person dies.
Right.
So to use our example, if the person sold that first edition copy of To Kill a Mockingbird before they passed away, John Smith, who's named in the will to get it, gets nothing.
Right.
The gift basically disappears.
Wow.
Because the item, the thing, no longer exists.
So even if the will is totally legal, that specific gift could just poof, be gone.
Gone.
Wow. Okay, so that's definitely something to keep in mind.
Yeah.
What about general gifts?
Okay.
Because these sound a little bit less concrete,
Yeah, you're right. General gifts aren't tied to one specific thing.
Huh.
Instead, they're more like categories of items.
Okay.
Or a certain amount of money that can be taken from the person's estate.
I see.
To satisfy the gift. So the source material mentions my car or my watch.
Right.
Without saying which car or which watch, and that's what a general gift is.
Okay, so let's say someone says my car, and they actually have 3 cars.
Okay.
Does the person who's in charge of sorting out the one will just get to pick which one they get? Or what if they don't even own a car when they die?
Yeah. So what happens then is the executor, who's the person in charge of the estate, would have to try and purchase a car to fulfill that gift.
Right.
But importantly, if the estate doesn't have enough money to buy the item, the gift fails.
Got it.
And, it's worth noting that it's not a free-for-all. The executor can't just pick any car. They have to kind of act reasonably and in line with what they think the person's intentions were.
Right.
Based on the will and everything else they know about the person.
Makes sense.
Yeah.
Okay, so we've got specific, that exact thing, and general, sort of like a category of something, and then we have these demonstrative gifts.
Right.
Which sound like a bit of a hybrid, a mix.
Yeah, you're exactly right.
So what are those?
So a demonstrative gift is a gift that's supposed to be taken from a specific source. So it could be a specific bank account.
Okay.
Or maybe the money made by selling a certain asset.
I see.
But here's the thing. If that specific source doesn't have enough to cover the gift, or if it doesn't even exist anymore, then the rest can be paid from the general assets of the estate.
Oh. Okay.
So it's it has a preferred way of being paid out.
Right.
But there's a backup if that preferred way doesn't work out.
I see. So it's you try and do it this way first, but if that doesn't work out, then there's a fallback.
Yeah, exactly. And if the specific source is gone entirely, the gift basically just becomes a general gift at that point.
Got it.
Yeah.
Okay, and that makes it gives the person getting the gift a little bit more security
than
just hoping that one specific thing is still around. Really.
Totally.
Now, the source material also talks about these pecuniary gifts,
Yes.
which I'm assuming has something to do with money.
Yeah, pecuniary gifts are pretty straightforward.
Okay.
It's a very specific amount of money,
Got it.
left to someone in the will. And the source material points out how clear these are
Okay.
because it's an exact amount. It has to be paid out from the estate,
Okay.
which might mean selling off some stuff to get the cash.
Right.
But here's the thing. If there's not enough money in the estate to pay all the pecuniary gifts, they might have to be reduced proportionally.
I see.
Like everyone gets a smaller slice of the pie.
Right. So if the money's tight, everyone sort of has to take a hit.
Yeah, exactly.
Okay. And then finally, we have residuary gifts,
Okay.
which I'm assuming is just whatever's left at the end.
Yeah, you're right. It's what's left of the estate after all the debts are paid, the taxes,
Yeah.
expenses, and of course all those other gifts we talked about.
Oh, right.
The specific, general, demonstrative, pecuniary, all those are taken care of first. And whatever's left is the residue. And that could go to one person or it could be split between several.
Okay.
It's like the final sweep up, in the will.
Okay. So we've got these different types of gifts.
Yeah.
And it seems like each one has its own set of, rules and its own set of potential problems.
Absolutely.
So let's get into those problems.
Okay.
How can these gifts actually go wrong? And the first thing that the material mentions is that even if a will is completely legal, some of the gifts in it might still fail.
Yeah.
That seems counterintuitive.
It does seem counterintuitive, right?
Yeah.
Because you'd think if your name's there, you're getting something, but, as we've already seen with ademption, that's not always true.
Right.
The first reason for a gift failing that the source material mentions is uncertainty.
Uncertainty, what do you mean?
So we're talking about when things aren't clear in the will.
Okay.
Either it's not clear who the gift is for,
Right.
or it's not clear what the gift is. So if the way it's written, makes it basically impossible to figure out who should get what or what that specific item is,
Right.
then the court might have to say, well, that gift just isn't valid.
Okay.
But there's a really interesting exception
Okay.
when it comes to charitable donations.
Right.
This is important. So even if the person writing the will was really clear that they wanted to give to charity,
Okay.
but they didn't name a specific charity, the court might step in
No.
and try to figure out a suitable charity, to receive the money,
Okay.
as long as it's really obvious
Yeah.
that the person wanted the money to go to a good cause.
Right.
You know?
So lesson number one,
Yeah.
be really clear in your will.
Totally.
Right. Makes perfect sense. The next reason that a gift might fail, is if a beneficiary witnesses the will.
Oh, yeah, that's an important one.
Like, that sounds like a pretty black and white rule, doesn't it?
Yeah, it is quite strict.
Yeah.
Section 15 of the Wills Act, 1837, is pretty clear about this. If someone who's going to inherit something from the will, or their spouse or civil partner,
Right.
signs the will as a witness,
Yeah.
their inheritance is no good.
Wow.
It doesn't count.
Okay.
Interestingly, though, the will itself is still okay.
Got it.
And that person or their spouse or civil partner can still be a witness
Okay.
to say, yep, this is the real deal, I saw it signed.
I see.
So the will's okay, but that particular gift is off the table.
Okay, so the will's still good,
Yeah.
but that specific gift just goes away.
Mm-hmm.
What's the thinking behind that? I mean, it seems a little unfair, doesn't it?
So the law is trying to prevent any sort of conflict of interest or someone being forced into signing something,
Yeah.
They want the witnesses to be totally neutral
Right.
and not have any personal stake in who gets what.
Right.
Because if someone stands to gain from the will,
Yeah.
and they're also the ones signing to make it legal, well, it just looks fishy.
Yeah, yeah.
It's all about keeping the will-making process honest and trustworthy.
Right, yeah.
And it's interesting that the source material points out this rule applies to spouses and civil partners at the time of witnessing, but not to their kids or, people they just live with or future spouses.
Got it.
That's worth knowing.
Okay, so the next point is divorce or dissolution.
Right.
This one seems a bit logical.
It does, right. Section 18A of the Wills Act 1837 actually covers this.
Okay.
So if someone gets divorced
Okay.
or their civil partnership ends after they've made their will,
Right.
any gifts to their ex-spouse are treated as if that person had died on the day of the divorce.
So let me get this straight. If I leave everything to my husband and then we get divorced,
Right.
he doesn't get everything when I die, right?
Exactly. The law basically pretends they're no longer in the picture for the will.
Okay.
And the source material explains that if there's like a backup plan, in the will,
Okay.
that's called a substitutional provision.
Right.
It would say something like, if my husband dies before me, then everything goes to my children.
Okay.
That backup plan would kick in.
Got it.
And if there's no backup, the gift just fails.
Makes sense. Okay, so we're back to this word that we talked about before, ademption.
Yeah. Mm-hmm.
And the source material reminds us that a specific gift fails if the person who made the will doesn't own that thing anymore when they die.
Yeah.
So we talked about selling something, but it could also be given away or destroyed, right?
Yeah, exactly. The key here is that the specific asset isn't part of their estate anymore.
Okay.
And like we said, if that happens, it just goes into the residuary estate, the leftovers.
Right.
And the source material makes a really important point that just because something changes its name or its form doesn't mean ademption happens.
Okay.
It has to be a real change to the thing itself.
I see.
So, for example, if a company changes its name, shares in that company are probably still going to be considered yours. The tricky situations are when the asset changes a lot.
Yeah.
Like the person sells the specific thing, but then buys something super similar just before they die.
Yeah, okay.
Those cases can be really complicated, and you really need an expert to work it out.
Got it.
And it mentions codicils as well, which are like updates to a will.
Okay.
Which are really important because they can affect whether ademption has happened or not.
Got it. So it's like hitting the reset button on the will's timeline.
Right.
Okay, now the next term that the source material mentions is lapse.
Okay.
And this one sounds like it has something to do with the person who's supposed to receive the gift,
Absolutely. A gift lapses if the person it was intended for dies before the person who made the will.
I see.
Now, unless there's a specific clause in the will, a substitutional gift clause, which basically says who should get it if the original person dies.
Okay.
It just falls back into the residuary estate, the leftovers.
Right.
But the source material clarifies that even if the beneficiary, the person getting the gift, only lives for a little while after the person who made the will dies.
Okay.
The gift is still valid, it just goes into their estate.
Okay.
Unless the will says otherwise, of course.
Right.
And there's also this general rule that a will speaks from the day it was written,
Okay.
Which is important in these lapse situations.
Right, so you got to think about having backup people named to your will if you want to have some control over where things go.
Absolutely.
Right.
Absolutely.
Now, what happens if someone just doesn't want the gift?
Okay.
I mean, that's covered under disclaimer.
Right. You can't force someone to take something they don't want.
Right.
They have every right to say no thanks.
Right.
That's a disclaimer.
Okay.
And if they do that, it typically goes back into the residuary estate, the leftovers.
Okay.
But if someone disclaims the residuary gift itself, that's when things get a bit more tricky, and the rules of intestacy might come in.
Intestacy.
Which means that it gets divided up according to the default legal rules for people who die without a will.
I see. Okay.
And the source material mentions Section 33 of the Wills Act, 1837.
Okay.
Which says that if someone disclaims, it's treated as if they died before the person who made the will.
Okay.
And so their kids might actually be able to take the gift instead.
I see.
But the source material also notes that if you've already started using or benefiting from a gift, it's assumed that you've accepted it.
You can't pick and choose once you started, taking advantage of it.
Mm-hmm.
The next section is forfeiture.
Yeah.
Which is a much more serious topic.
It is.
And this deals with what happens if someone kills the person who made the will.
Right. So this is a huge principle of public policy that basically says you shouldn't be able to benefit from doing something wrong.
Right.
So if you unlawfully kill someone, you generally can't inherit from them, whether it's through their will, default rules of intestacy, or even shared property that would normally pass to you automatically.
Right.
And the source material gives us examples like murder, manslaughter, encouraging someone to commit suicide, or even causing death by reckless driving.
Okay.
But it also notes that if the person was legally insane when they did it, this rule doesn't usually apply.
I see.
So in that case, are they treated as if they had died before the person whose will it is?
Generally, yeah. And again, Section 33 of the Wills Act might mean their children could inherit instead.
Right.
And the source material also mentions the Forfeiture Act of 1982, which allows the courts to sometimes modify the forfeiture rule in cases other than murder if they feel it's fair to do so, considering all the circumstances.
Okay.
But there's a deadline, 3 months after the conviction to apply.
So the law is trying to make sure that no one benefits from doing something terrible like that.
Exactly. And this leads us to a specific legal case mentioned in the source material, Ninian v. Findlay from 2019. This one was about assisted suicide, which is obviously a very sensitive topic.
Very sensitive and complex, yeah.
So what happened there?
So Mr. Ninian, who had terminal cancer, decided to go to Switzerland, where assisted suicide is legal.
Yeah.
His wife, Mrs. Ninian, while she didn't agree with his decision, she helped him make arrangements and even went with him. So despite that, the court decided that Mrs. Ninian was entitled to inherit her husband's money, which was, a lot of money. 1.8 million pounds.
Wow.
The source highlights 2 main reasons why they made that decision. Firstly, the court didn't see her actions as encouraging him, especially because she'd been against it all along. And secondly, the Crown Prosecution Service, the ones who decide whether to prosecute someone, decided not to go after her. And the source material says that this decision by the CPS is going to be really important in similar cases going forward.
Got it.
It shows how complex these issues are.
Yeah. And it really shows how much each case depends on its own specific details.
Absolutely.
Right.
Totally.
Okay, now the material touches on the legal implications of gift failure.
Right.
And it sounds like we're back to the residue again.
We are.
So explain what that means.
So if a gift doesn't work out for any of the reasons we've talked about, and there's no specific person named as a backup, it usually becomes part of the residuary estate, the leftovers. And if there's no residuary clause at all, that's when the rules of intestacy kick in.
I see,
Which means it's divided up according to those default rules. So it shows how important it is to have a well-written will with a clear residuary clause.
To cover all the bases,
Exactly, just in case.
Okay, and now the source material gives us this sort of example, this task, involving Eleanor and her nephew Tom. And in her will, Eleanor left her house to Tom. But before she died, she sold the house and moved into a care home.
Oh, wow.
And so Tom wants to know if he's entitled to anything. And it seems like a really clear example of ademption, right?
Yeah, this is a classic example of ademption. Because the house, the specific gift, wasn't part of her estate anymore when she died. So the gift is deemed, unfortunately for Tom. It looks like he wouldn't be entitled to any other asset or money.
That specific gift is just gone.
It's gone. It's extinguished.
And this shows why it's important to keep your will updated.
Yeah. Absolutely.
If your major assets change.
If you sell a house, you need to update your will. It's not enough to just list your possessions. You have to think about what might change.
Got it.
Over time.
Important lesson there. Okay. The material also includes some multiple choice questions. Which are a great way to see how all these ideas work in practice.
Yeah, totally.
And we've got questions about specific versus general gifts. What happens when there's a divorce? Ademption, of course. Disclaimer, conditional trust, bequests, all sorts of stuff. We're not going to go through the answers now, but it's interesting to see how they apply the rules that we've been discussing.
They do, and they really highlight how, different types of gifts and life events can have big consequences when it comes to understanding and carrying out a will.
Right. So to wrap things up for you, listener, this deep dive into how gifts are interpreted and distributed shows that the law is both interesting and sometimes complicated. Knowing the different types of gifts, specific, general, demonstrative, pecuniary, residuary, that's just the beginning.
It is, yeah.
Understanding all the different ways a gift can fail. Like ademption, lapse, disclaimer. Forfeiture, is important for anyone involved with a will. What's really fascinating here is this back and forth between what the person wanted, how they actually wrote it in the will, and the rules that govern it all.
The legal rules.
It's why it's so important to think carefully.
Absolutely.
And often to get help from a legal professional.
Yeah, definitely.
When dealing with a will.
Totally.
Which brings us to our final thought for you.
Okay.
Considering all the different things that could happen with a gift and a will. Things you might not even think of. What steps would you take to make sure that your wishes are clear and actually happen the way you want them to?
It's a great question to think about.
Absolutely.
Hmm.
Absolutely. And on that note, let us know what other topics you'd like us to take a deep dive into,
Yeah.
in the world of law or personal finance. Let us know what you're thinking,
Yeah.
and we'll see you next time.
See ya.